Welcome back to Sunrise Daily. Mr. Omodara Samson joins us today as we'll continue our focus on the Constitution amendments. Remember, the Senate did talk about, deliberate on some of them, even the members of the House of Reps, before they haven't done that this week, actually. But remember the 6-year single term, it goes on. Morning, and thank you for coming on today. Brother. Well, yes, you are in touch with this amendment going on, but the one that they talked about this several times. It was eventually debated, and they just said no way. They wouldn't accept that, the 6-year single term for president and governors. And then there's a lot of list. I mean, the list is quite long. We'll take them one after the other. But perhaps having seen all of those amendments and how they're going about it, what's your impression of what they're doing so far?
Well, I have not seen a genuine effort on the part of National Assembly. There's always been this hue and cry about the originality of our Constitution. As regards the preamble, we, the people of Nigeria, make the following Constitution for ourselves. Since we have elected these representatives, both at the House of National Assembly, both houses, what would have expected from them to take proactive steps since 1999 to ensure that we have people-oriented constitution. That has not been done since 1999. All we've been hearing from them is we are going to amend some provisions of this constitution. That has not been done till today. So in spite
of all these attempts that are being done now, you don't think it amounts to or come close to what you're talking about?
I would have expected them, even before now, that a lot of sections of this constitution should have been amended to suit the purpose of this nation, the governance of this nation, the modus operandi of the entire country. That has not been done since 1999. All we kept on hearing, we're going to amend sections, these certain sections, and majority of these sections that intend to amend has to do with politics. They should go to the nitty-gritty of the Constitution, that the sections that will benefit our people.
Like which one?
Like Chapter 2.
Okay.
Chapter 2 should be made justiciable. The fundamental principles and directive policies of state politics should be made justiciable, so that economic rights, you can go to court and challenge your state governor that you have not made provision for on so based on your promise during electionary campaign.
How would that happen if they talk about the governors not being distracted by civil suits, and so, okay, for criminal matters?
For criminal matters.
Okay, so you want them to put that provision in the laws?
Let that chapter be justiciable. And also, I'm also looking at the provision of Section 9 itself. Should also be amended to ensure, because the way that section states now, the amendment process has to start from National Assembly. And if you look at the composition of National Assembly vis-a-vis Section 47, 48, membership, if you look at the membership of House of Assembly members throughout the country, you know they are much, much higher than the numbers at National Assembly. And the concurrence of state houses of assembly has to follow whatever step taken by the National Assembly. What I'm suggesting is a situation where amendment of this constitution, we have to start from state houses of assembly, wherein 2/3 members of these houses we initiate amendment process, and that will also be concurred by National Assembly. The other way around, because if the National Assembly sleeps on its fundamental principle, duty, which is lawmaking and constitutional amendment, the state houses of assembly can also initiate such. I am talking that section should also be amended to reflect that something.
So, if the states decide that this portion is not right, they can lobby amongst themselves and then force the National Assembly.
If there is concurrence from the houses of assembly we have in the entire country.
Would that represent the desires of the people?
Yes.
Because that's where you started.
Yes. They are our representative. Both at the state house of assembly and National Assembly. They are representing Nigerians from different constituencies.
Wait, I don't understand here. If it starts from the state.
Yes.
You say
that's not the provision of the Constitution itself.
No, that's not 9. No, you're suggesting that.
Yes.
Now, if they do agree and it starts from there, you say that will be representing the people.
Exactly, but because the members of this House of Assembly will have probably consulted with the people at the local level, And at the National Assembly, they are far away from us here. Somebody in River State, in Maiduguri, in Lagos State, a member of Lagos State House of Assembly will go to either Ikorodu constituency or Ekpe constituency, dialogue with these people, and know what they want, and probably pass that across to the House of Assembly. And if that state House of Assembly agrees, or the entire membership agree on that provision, they could lobby other state House of Assembly and probably get that passed and forward that to National Assembly.
But from what you've seen so far, because, when they talked about that, I think they called it People's Parliament or something, when they went to constituencies to do almost the same thing which you talked about. Well, to some of them, they think, if not all of them, they think that's the way it ought to have been done, and that the amendments...
My brother, I think that was a jamboree.
Whoa.
That was a jamboree. What I expected them to do, each member of each House of Assembly should go back to his constituency, seek his people's opinion, seek what they want, and come back to the state of House of Assembly, collect all the opinions as emanated from each constituency, then form a kind of quorum, either 2/3, agree on a position, then pass that to other Houses of Assembly and forward it to National Assembly. And I also want to suggest that there should be, just like the state has this veto, overriding veto, if the entire states in the country agree on a particular reformation in this constitution, that should go. That should go in. That should, having done that, having consulted with their constituents, that should be the position of the law.
So if a state agrees, and of course it's about numbers, and most other states don't, they can't go in.
They can't go. That's the thing. But they have to lobby to look at the genuineness of that initiative, and they have to lobby and convince other states House of Assembly.
But from what you've seen now, because maybe subsequently we can look at some of the other provisions that have come up for amendments. Let's start off with this one about autonomy for local governments. When the Senate considered that, they rejected it.
It's also an aberration.
But remember, the House of Reps said they had sought the input of local governments with this particular autonomy request. And even the local government also rejected it. And so everybody thought, well, this is supposed to be to their own benefit. But they say no.
Well, it has to do with the caliber of people we have I'm not trying to condemn the entire local governments we have in the country. But if that is the concurrence of their opinion, the local governments we have in this country, over 700 local governments, so be it. Because we elected them, some were appointed by their godfathers, and if that's the concurrence of their opinion, not to have independence, so be it.
But how do you reconcile what the outcome of that Senate debate is, rejecting the agitation for local government autonomy while they were passing that bill for the 1999 Constitution alteration? And then what some people are saying, yourself inclusive, that this is what's best for us. But when it gets there, they say no. And when they say no, they also say, well, this is what the people want.
Well, it has to do with politics again. And I'm saddened when I hear some of these issues, because governors of all the states, if you look at it from 1999, we have not had anything good from governors vis-a-vis the interaction with local government. They see local government chairmen as their boys. They'll probably push around and tell them what to do. We've had, though not confirmed, that when they have allocations for local government coming from national level, all some state governor would do, just to remove some millions, and just you take 10 million, go and arrange borrow for some local councils, which is not the best for this country. But in a situation where the governors allow local government chairmen to have autonomy, they know they will be able to execute more programs for the people. And don't forget, they are the ones that are more closer to the people. The impact of governance will have been felt if local government chairmen are allowed autonomy with maximum supervision.
The argument is that the local governments enjoy some form of autonomy right now, but they are not doing anything.
I don't think so. I don't think so. And it's ridiculous if there is this opinion, as put forward by my brother now, that they rejected their own autonomy. They should know that there's politics underneath, because everybody will have to be independent. We fought for Nigerians' independence. So I don't see where somebody will throw the carrot at you. Oh, please take and have your independence, and you say no. It's not done anywhere.
Do you think the sharing formula as it is now, and from the federation account, the federal about over 50%, states about 24 or thereabout, and then the local governments about 21 or thereabout. Now, if this is going to happen, the local government gets autonomy, how would it work with the kind of sharing formula?
How has it been working in the past? That's the
Has
question.
it been effective?
It has not been effective. Even if they have this autonomy, the percentage that is allocated to local government councils all over the country, is it enough? And if it is not enough, will our chairmen also do the needful with the meager resources that comes to them? Would they do the needful? Would they do people-oriented programs? That's the question we should ask ourselves. And the answers are best known to all of us.
But don't we assume that the local governments will always do what is best if they are allowed that autonomy, function properly, without perhaps considering the kinds of people who occupy those positions? Isn't it the same way that we expect that leaders at the national level will do what's best, yet to complain time and again that they are far from it in most cases?
The question has to do with our mentality as Nigerians. I see no reason. If you go to other countries, you will see that the common good of common men has always been the primary purpose of government. You cannot see President Clinton of the United States of America. That's the first citizen of the world, as I say it. If you see any other Americans, you hardly see any difference in terms of look, in terms of welfare and everything. But the same thing is not applicable in African countries, particularly Nigeria. It has to do with Nigerian mentality.
Some of the other provisions, while they rejected this bill for the local government autonomy. And then, I see this one now, elections, about the elections, where you have to conclude disputes within 180 days. But you said most of these things have just got to do with with politics and elections, and that these are not the fundamental ones. But can we say that perhaps lawyers